My name's Tom King, and I'm the founder of Toolkit.law, and I'm joined by a well-known attorney in my jurisdiction in the United States, in the country of Texas, which is Glenn Brenner. Of course, if you're a Toolkit.law member and you're watching this continuing legal education webinar, you're in one of the 80 countries with English-based legal systems. So we're going to be obviously addressing this topic. The topic today is mediation general sessions and breakout sessions. I'm joined by a friend and a well-known attorney in our jurisdiction, Glenn Brenner. Glenn, it's great to see you again. I see a help sheet that you've done. I'm going to go ahead and share it on the screen, and we're going to jump right into this topic because we only have 7.5 minutes per column. Let's talk about when it comes to mediating general sessions and then breakout sessions. Let's cover first your green column on the left. What do you want to focus on here?
Well, first of all, thank you, Tom. Thanks for the introduction. When we're talking about mediations and being prepared for mediations, the first column, the first row that I put in the left side column is advise if family violence exists. And so, you want to talk to the parties that come in. Obviously, first and foremost, you want to warn your clients that they shouldn't be talking during opening and general sessions until you advise them of the opportunities to get done with positive, straightforward communication. Everything that we talk about today is going to be about coming into mediation in good faith. And what I mean by that is, as the attorney, obviously anything that's said in a mediation is confidential, and the mediation can end at any time on any party's request. But you want to go to a mediation in good faith. You don't want to go to a mediation, knowing that you're probably not going to settle. A waste of time, a waste of money for your client. So, but general sessions, when both parties are there, there's no confidentiality with the mediator. So you have to be careful and really kind of have good client control to explain to them that this isn't something, when we're in a general session or an opening. Some mediators like to do openings, mandatory, some don't. When you're in an opening type situation, let's just listen.
I like to do an opening, but you attorneys keep cutting me off. I have so many attorneys who object to it, but I also want to mention, obviously, as a family law attorney, you're approaching mediation from a family law perspective. So when we talk about family violence, that's usually a topic within family law or child welfare law. But, your help sheet can also be helpful for civil mediations and other types of mediations as well. Go ahead and continue.
Thank you. So, and obviously that's allegations of family abuse or family violence are the thing is in family cases, like you brought that up, Tom, and it's a good point. Like in family mediations, there's a lot of emotion, sometimes much more emotion than your average civil that you're just talking about mediating.
Right.
And so it's very important to make sure that you check the emotion at the door. I like to try to, if I'm not the mediator, but if I'm an attorney that's mediating a case with a mediator like yourself, Tom, I like to tell my clients to refrain from, because you can really hurt yourself in the case. So check the emotion at the door and let's treat this like a business decision. Some mediators like yourself, I've mediated with you, Tom, you being the mediator in my cases. Some are fantastic and will assist me in shutting down my clients. But some mediators don't do that, and they'll let things go as is. So
that's right. Sometimes the mediator needs to play the bad cop because you can't burn your own credibility with your client, but you can always throw the mediator under the bus. So why not?
Right. And even I might not follow exactly down the column, but that goes to preparation. So Tom would know this because I've mediated cases as the attorney. And so as the attorney, I like to give the mediator as much information as I can. I not only want them to understand why I think I'm going to be successful in this case, but perhaps more importantly, I want the mediator to see the bad parts of my case. That's super important to me. The mediator's bound to keep it confidential.
That's right.
And a lot of times the beauty of mediation is that the mediator will help me get this case settled and sold to my client. So I think most mediators, when I act as mediator, I love it. I think you, Tom, love it when you get more information than you even need from the attorneys, because
Especially when it's in the form of a mediation memorandum at least 24 hours in advance. And
mm-hmm,
and when I go into a breakout session with an attorney like you and your client, you always end up you have the lawyer remind the client, hey, Tom's going to beat us up in this room, but he's going to beat up the other side in the other room, so that we have a third party perspective on the strengths and the weaknesses of our case, so that as you're deciding whether or not to settle the case, you're balancing that against the likelihood of prevailing or not prevailing if we go to trial, and what will not only be the financial but the emotional and personal cost, aside from how much you pay me to try this case for you.
that's right. And Tom's real good as a mediator about sending out the emails. And I've got a question for you, Tom, about sending out the emails that, you and in preparation, the package, basically suggesting that the attorney prepare that mediation memorandum.
Oh
so
yeah.
that so that you're providing that to the mediator, get the mediator better prepared. But some mediators don't do that. If you want a sample of a mediation memorandum, you can find it on Toolkit.law. Tom could tell you where to find that.
In
But
fact, I'm showing it on the screen right now. So it's in our mediator tool in the tools section. Not only do we have a mediation memorandum generator, in which covers all the topics that you want to be covered and prints it out, but we also, what I really love is we have an offer analysis to help you show financially and emotionally if you can assign a cost you say to a client, aside from what you pay me, what would you assign a monthly financial value of what it'll emotionally cost you for each of the next 6 months if this goes on? We have an offer analysis tool that helps them factor in whether or not they should accept it or not. And I'm showing that on the screen right now, I believe, or am I not? Yeah, I'm showing it on the
yeah,
screen.
yeah,
Um, and it is a great tool. It is a great tool. But the other thing about a mediation memorandum, regardless of the country you're in, you are always exposed to liability if a client sues you or if a client files a grievance. There is no better insurance against a grievance than if in mediation you submit a mediation memorandum. And then if you get sued by a client or you have a grievance filed against you, have that mediator put together an affidavit for your grievance that says, only 5% of attorneys do mediation memorandums. This was one of those attorneys, and here's a copy of the mediation memorandum. He or she was above and beyond prepared before and during mediation. And to me, not only is it the best way to prepare for mediation, it's the best way to have a prepared, successful defense against any possible grievance.
yes. It also is going to make the mediator. You're there. You're spending money. You're paying. Your client is paying for this mediation. If you take the time, and you can bill your client obviously for the time that it's going to take you to prepare the sentencing memorandum, your likelihood of success. Tom would have better figures as to this. Likelihood of success when both attorneys are giving him very comprehensive sentencing memorandums, as opposed to the probably
Oh yeah.
90% of the time where they don't,
Oh,
even though
God.
you're requesting it.
I settle 93% of my cases on final orders, And when at least one of them has a mediation memorandum, it's like 97%. And if both of them do mediation memorandums, I would guess it's 98%. I know it's
Yeah.
93% without, and I know it's 97 when one does it. Let's go ahead and go back to the help sheet and let's keep tracking that help sheet. So you have payment confirmation ready. That's important. Have court admissible exhibits ready. I actually include exhibits in an exhibit list with my mediation memorandum. Advise the mediator if you require breakout sessions. What else?
And
What else in this green column do we want to cover before we go to the yellow column?
yeah, so uh, uh, I think, and this is again going to help the mediator, which is going to help you be more successful. And that's the very last. Most of them are pretty self-explanatory, but the very last one, have offers and ranges prior to mediation. I would think, as me being a mediator, and I think you too, Tom, it's a pet peeve of mine when the attorneys come into my mediation, and I'm doing it. I'm collecting the money, so it's kind of a waste of time if they come in with no idea of what they're asking or wants. I mean, and I've seen that happen, and now it's like, really, you're paying me to settle your case? I know the least about your case. You two know the most, and you're paying me to now, like, figure it out and settle it. Come in with a plan. Talk to your client about a plan. Don't let the mediator. It's going to be easier and more effective if you come in and tell your client, this is what I want. This is where I think we should be. And if we do better, great. We'll start here. And then the mediator can work through that.
And Glenn, I mean, how many times do lawyers basically use mediation as discovery?
Yes.
They don't do that.
Yes.
They don't want to do the work. I say, okay, what are the list of the financial accounts and what are the last four digits of each account and what are the balances? Oh, that's a good question. Let's look it up now during mediation. Oh my stars. Oh my stars. I mean, my goodness. That's like
Yeah.
a sign of malpractice right there.
It really is. It really is. And it's unethical in the sense that
Yeah.
you're not coming in with good faith with an attempt to settle this case at mediation. I mean, if one side's doing it and the other isn't, it's just frustrating for the lawyers. So be prepared and prepare your client and be ready to get to a settlement so that you can clearly tell the mediator, this is what I want. And then the mediator can then say, here's your best day in court, here's your worst day in court, and then you can find that common ground.
Perfect. We're finished with the left column, jumping to the right. What about general sessions with from the mediator's perspective? So if it is a family law case, you have a duty to determine in advance if family violence exists because in many jurisdictions in the 80 plus countries with English-based legal systems that are the target market of Toolkit.law, you cannot bring them together in the same room. Certainly in our jurisdiction, in the country of the United States, in the state of Texas, you cannot put them in the same room if family violence exists. But you know what? Sometimes it may be a civil case, and you may find out that one of the parties has previously been through a trauma unrelated to the civil case, but still might affect how they behave in a mediation. For instance, if it's a woman who is traumatized through a divorce and went through a difficult mediation, now she's involved. It could be a man, but it's usually a woman, right? And
Mm-hmm.
it's a
Mm-hmm.
civil case and she's a party and she has bad memories of a mediation. She doesn't want to go face to face in a mediation. Anybody could be the subject of trauma. So I always try to find out, does anybody have previous trauma that would affect the ability of us to be in the same room together? Because as I think you know, Glenn, I was the attorney in America that invented online mediation in 2017. And I remember making all these mistakes and then finding out about I was bringing people together, and I'm very unusual in America. Many times in family law cases, I'll have everybody together for 80% of the mediation. And I only had to make that mistake a couple times before I asked proactively, Is there any family violence that I need to be aware of, or trauma that either party has suffered that would not that would make mediating in the same room unproductive? And when I started asking that last point, boy, did I start finding out more that helped me. So determine if family violence exists, advise
Yes.
participants what is and is not acceptable behavior. You always want to confirm the payment. I always require mediation check-in 15 minutes in advance. Why? Because it takes 15 minutes in advance for everybody to find proof of payment and everybody to get online and everybody to be ready. Okay.
And in America, I can tell you, I think I'm comfortable suggesting you're not going to find a mediator that doesn't take payment in advance. I don't know what happens in other countries, but it's super important. Once you mediate a case, the last thing a mediator wants to do in his business is trying to chase down somebody to get paid. And believe me, there's buyer's remorse. There's things that happen. Mediation's a great thing, but there are things that happen after mediation, and mediation is binding in America. So there are laws that suggest that once you sign and file, they are binding agreements, and that's a beautiful thing because you always get not always, but a lot of times you get buyer's remorse after this. So if you got a client, and what I mean by that is they're agreeing to it at the time because it sounds, and it is the best agreement you're going to be able to come up with. And then afterwards, they get mad at the spouse or mad at the business partner and decide I should never have done that. Well, they're locked in, but now go try and collect from somebody that's unhappy with the mediation. So collect in advance. Otherwise, you're just not going to run a successful
So,
business.
I'll tell you the policies that I ended up adopting when I started this in 2017 and doing it online. Number one, payment is due the day of scheduling. Period. End of story. It's due the day of scheduling. If your clients aren't ready to pay now, don't schedule it now, because I do about 10 mediations a week. And if you schedule something you can't pay, you're basically taking out the cost of each party out of my pocket as mediator if we end up getting to that day, because I never mediate unless I'm paid. Okay.
Right,
First,
right.
the policy number one, payment is due the day of scheduling. And in America, I only accept Zelle, Venmo, Cash App, and PayPal. Zelle, Venmo, Cash App, and PayPal. In different countries, you'll have different electronic methods. Everybody can do one of those four in America now, regardless of how much they make or don't make. The second policy I have is I'll refund fully if you cancel with at least 14 days notice. Anything less than 14 days, I'll reschedule within 30 days, but I will not refund. And anything canceled less than 72 hours, I will neither refund nor reschedule, because you're taking money out of my pocket. And to me,
That's right.
those are the three key policies that you have to do as a mediator. Payment due the day of scheduling electronically. Cancellation's okay as long as it's less than 14 days. And if it's less than 3 days, you neither get your money back nor you reschedule, because I only charge $400 per side per party, which is like the cheapest in my jurisdiction. But I don't like to make less than the cheapest, right?
Right.
So
That's right.
if somebody doesn't show up, I always give the other side that paid a choice. And I share it like this. I say, will the parties agree that if we have a resolution, that the cost of the mediation for one side that wasn't paid will be included in the settlement to the other?
Yeah.
And will they also agree that if we don't reach a resolution, that I tell them that I'm going to include it in the notice of impasse to the judge. And in the notice of impasse, I'm going to say both sides showed up, but only one side bothered to pay. Judge, please factor this in. And there's nothing a judge hates to read more than one side freeloaded off of a mediator.
Yeah.
So let's keep going down this column, because we're talking a lot, but we're not getting through our help sheet. So
No.
confirm
Yeah.
reviewing mediation memorandum, request parties to try a general session if appropriate, review benefits with both sides and the rules for breakouts. And I say, If either side requests it, I'm gonna grant it immediately. Warn against and do not tolerate unprofessional behavior. This applies not only to parties, but to attorneys. And whenever that
Yes.
happens, I immediately take the two attorneys to a separate breakout room and I chew them out outside of the presence of the client. You cannot allow any unprofessional behavior because you don't know what trauma one of the parties may have been through previously and not disclosed, or that you have an attorney who's never been called to task, never been called on their behavior before, and they need to. Because once they find out, once it gets out that they can run over you as a mediator, people will be
Yeah.
coming for the wrong reasons as a mediator.
That's right. That's right. And especially again in family law cases or a case where the emotion is getting the better of people, this can happen. And sometimes attorneys write letters or memos or emails, and you wonder who they're writing it, who the audience that they're writing it for, because it's nasty. And so at that point, I think as a mediator, and Tom's real good about calling the people out on this, not in front of the clients, but explaining that you're not doing a service to your client, and we need to get back to the business decision of this mediation. Another thing that's super, super important that I think I learned from Tom actually is it's rare that you're going to get out of a mediation with Tom King and have just an agreement or a term sheet. One of the things that I think is super important as a mediator is finalize that order, and it's one of the last items on our cheat sheet. But Tom's real good about no. We're not leaving this stone unturned. I don't want to leave this up for interpretation. I'm putting the language in, and if I have to stay late to do it, I'm doing it. And it's so helpful to make sure that you have a finalized specific order with everything in it, because you don't want your mediated settlement agreement to be litigated in the future.
Right. Now
And
let's go next. Now let's go to the second page. Back now we're
yes,
on the blue column, which again is your column on what to
yeah.
do in the breakout sessions. Talk to us about this as you see it on the screen.
So I think you got to be. I think the most important. I mean, share areas of agreement and deal breakers. Share game changing evidence. Those are self explanatory. The third one: be realistic with your client. I like to say this is our best day in court. You're not being realistic. I will tell my client that is not a realistic approach to this. And then I think I've got down here somewhere about be liberal with the future legal costs.
Oh yeah.
You need to tell your client what this is going to cost you. Yes, you're not getting exactly what you want, but do the two of you want to continue to fight and spend all this money where it could be going into the family, like for the benefit of children in a family law case? You want to give it all to the attorneys because that's what's going to happen. And so be realistic and be very generous and liberal about how much this is going to cost as a means towards settlement.
Game changing evidence. My favorite story that attorneys in different countries may be shocked when I say this, but it's a family law case I'll never forget. It was a divorce. They were fighting over custody over the children. And one party brought a video. The wife brought a video of the man in a sexual business receiving oral sex by someone there. And they showed me this video, and there were like tons of people there. This person was doing it in a room with like 30 or 40 or 50 people. And the wife goes, show this to the other side because this is what will show the jury. Sounds terrible, right, Glenn?
Yeah.
I go to the other room. You know what husband says? Go ask my wife who shot the video. She was the one, she was the one holding the camera. And I go back into the other room and I go to the wife's attorney. I said, would you please ask your client right now who shot the video? And that attorney goes, what? I said, your client. So that attorney thought it was game-changing video, but it just made them both look like pieces of poop. Right?
Right.
It just made
That's
them
right.
both look like neither of them should be raising children. So
That's right.
if you
Yeah.
think it's game-changing evidence, I love this fake term I came up with in Latin, sanctus cacas. Holy shit!
Yeah,
If it doesn't make the other side say holy shit and stand up, you're worse off having shared it. Because
that's right.
what happened in that case, Glenn? Wife's attorney thought they had something great. And instead, what they showed the other side is that attorney hadn't even done their homework regarding the evidence that they thought was critical that now they would never use in a courtroom.
Which goes back, and as an attorney, you can tell your client everything. I am on your side. You're paying me. Everything you talk to me about is attorney-client privilege. I need to see the source of this case. I need you to tell me exactly what's wrong with this case, where we're going to, because if I'm surprised later, that's the worst I can be. And so in a mediation, that came back to bite that person. Now
Oh,
the mediation got settled less because of it.
yeah. Now, you say be realistic with your client. Don't make the mediator the bad guy. I might give you a little bit of pushback on that. There are times when uh, I need to be the bad guy, or I say, that's that to me, that's subjective. Share the range of the possibilities with the client. Determine how low your client will go as long as you're in a private confidential room. Be liberal with future legal costs. We covered that. um Talk to me about document
It's
sign.
let me go back to don't make the mediator the bad guy. It's a
Okay.
very gentle
Okay.
subject because you can make the mediator the bad guy, and all of a sudden your client's like, why do we have this mediator? And I'm not going to settle on anything then. So when I say that, you can do it, you can use it to your advantage. But I like to remind my client over and over and over, Tom is neutral. He is not working for them. He is not working for us. That's the beauty of coming to a mediator like Tom, is we've got a neutral perspective. All he's doing, he's not being the bad guy or against you. He just wants you to understand what happens if we go to court and how we might lose. So I like to have that approach rather than to say, well, I can't control Tom either, because what's going to happen it just depends how you do it. It's just, you got to be careful there.
Yep. Okay. Now, document signing and e-filing. I always do the e-filing as the mediator. What do you want to say about document signing?
I always do the e-filing as mediator, and I think in America, at least now, almost all the mediators that I've been to or that I hear about all do the filing themselves, and that way it's neutral and it's filed and it's done. One thing I would say as an attorney on the case, consider who's going to draft the final orders, because that's a big expense. And I'm usually in a mediation, once we're all tired and done with everything, I'm very successful in saying, oh yeah, one more thing, Tom. They'll have his attorney prepare the order. And it sounds like nothing. So his attorney's like, okay, I'll do it. But can be quite an expense. So think about that. And it's a way to.
And I will point out that in Toolkit.law, one of our tools is called Signer. So we do digital electronic legal signing, and it does also, if you wish, it'll include the physical address and the IP address in the international date and time. So if you're on a low budget and you can't afford some of the more expensive ways to do signing, Toolkit.law. If you go into our suites under documents, you'll find it right there as a signer tool right there. You'll also, if you go to Toolkit.law to our suites, you'll find it as in our mediation. It's also listed there in our mediation tool, or you can also find it by going just through our tools. But when in doubt, start with our suites and find the suite of tools that we've bundled to help you make it easy to find. Let's go ahead and continue with what we were sharing on the help sheet right here. Let's switch to the last column. We're going a bit over time, but that's okay. Let's go ahead and cover this last column, you and me, Glenn.
Okay.
Breakout and caucus rooms with mediators. Determine the areas of agreement in deal breakers. I always like to upfront, especially if I can keep it in an open session that is everybody together, especially with civil mediations. I'll have the party who filed summarize for me what they think there's an agreement on. And then I'll have the other side say, okay, yes, we do or don't agree to those things. And then I'll have the party that started the lawsuit summarize what they don't think there's agreement on and what their position is. And then I'll have the other side or sides summarize if maybe there is something that's an agreed to that the other side might not have realized. So if you can get 2/3 of the topics out of the way, what a great way to start a mediation where both sides or all three sides can say, wow, we didn't realize we had agreement on 2/3 of the items. And Tom, in the first 15 minutes, you helped eliminate 2/3 of the topics. Let's focus on these last third topics. Yeah, present
Right.
game-changing evidence. Yeah, make sure it's game-changing. Make sure it's
Yeah,
game-changing. Okay?
that's right.
Because if you share it and the other side says no big deal, it doesn't matter. And don't burn your credibility by being dishonest. My favorite story from family law is I had two couples who hated each other and everyone was mediating remotely and I had everybody in the same room, Glenn. And
Yeah.
the wife in this divorce, she goes, well, he does illegal fighting with roosters. In America, we call that cockfighting. Okay, she goes, he's got a dozen roosters that he uses for illegal fights. I want him to sell all 12 of them and I want half of it. And then he goes, and unfortunately, his window must have been opened by wherever he was sitting at the kitchen table. He goes, oh, I got rid of those roosters 6 months ago. And right then you hear cock a doodle doo out the window as all the roosters must have gotten the sign. They all started making the rooster sound loud right outside the window. And his lawyer to everybody goes, stop lying. Needless to
Well,
say
that's
that,
good. That's
yeah,
really good. That is,
in family law, we have more vulgar or crude examples, but to me, that was my favorite. That was my favorite one when the roosters got the cue and they crowed right on time. So
yeah,
share worst case scenarios with the parties in separate breakout sessions. I
that's right.
always I so enjoy as a trial attorney myself. I so enjoy say, will you allow me in this breakout room to pretend that I'm the attorney, the judge? They'll go, sure. I'll say, okay, if I ask you to summarize for the judge in 60 seconds the strengths of your case, what would you say? And then if the judge said, I insist that you outline in the next 60 seconds in this private breakout room for the benefit of your client the weaknesses of your case. And
That's
then
right.
I'll pick apart both and then I'll say, you know, as mediator, I'm not allowed to give you a legal opinion. However, if I had a friend in almost identical circumstances, it's highly likely I'd give them the following non-legal opinion. What the hell are you doing?
Uh, that's good.
How do you
That is
possibly
good.
how my friend, unrelated to this case, do you possibly expect? I'll never forget a dad who was guilty of cross dressing and had videotapes of him having homosexual sex dressed as a woman with someone else. He was fighting for custody of the child, and the mom was a decent mom with no bad things. I said, what do you think the judge is going to do when they see this scandalous and they may determine to be depraved video? Well, I don't know. I mean, I'm a good guy, to which I said, that is highly debatable.
Yes.
And
Yes.
I'm sure your attorney's already told that. And the attorney's
Yeah.
going, thank you, thank you, thank you
Right.
for telling them that, right? And so
That's right.
you need to be
So
blunt. You say you don't want the mediator to be the bad cop. I say, look, listen.
sometimes they have to be, but it's just a delicate line that you have to kind of walk, I think.
Yeah, it is.
Yeah.
It is. Now,
So
share worst case scenarios. Ask each attorney how they think the judge might rule. I'd love to do that. And I say,
yes.
especially if it's a matter of law, and I say, do you believe that your evidence meets the threshold of this law? Because if it says that the property had to have been purchased after the date of marriage, but there's a question as to whether the date of marriage is. Maybe it's common law marriage. Maybe it's traditional marriage. Maybe there's a question of whether or not they got divorced and then remarried to the same person, and the property was purchased during that gray area, right? So you got to
That's
really
right.
get on the facts quickly. And this, of course, this is where it's really helpful to have a memorandum from the mediator. So ask each attorney what they think the judge might do. Always lowball both parties. One of the things, Glenn, and Glenn is probably on purpose, but your camera and your microphone are muted. I'm going to keep talking. You know, always lowball what you can do. And I always love, usually with a mother, she says, I won't do anything for $600, anything less than $600 for child support. And I'll tell them, I don't think I can get more than 400, but I'll go into the other room. And then I'll tell the other side, I will say her low ball is 400. I'll say her low ball is 1,000.
Right.
And so he'll go, forget it. I'm only doing 800. And then he thinks he saved 200. And then I go back in the bad room. I said, I got bad news. I couldn't get you 600. I got you 800. And they go, you went above and beyond. And so both sides feel like they nailed the other side. That's
great.
That's
I
probably,
never heard of that, but that is
oh,
phenomenal.
that's my favorite family law strategy. How much do you need? What's the minimum you need? 600. Well, I don't think I can get them over 400. Let me go to the other room. And then I double whatever that side wanted and I share it. They say, I can't do 1,200, but I'll do 900. And I say, oh, come on, man. She's telling me that's her drop dead offer. 900, that's it. And so the party thinks they saved 300. The other party thinks they gained 300, that they didn't have a chance. And everybody feels like they screwed the other side, or they got the best out of the other side. And then the smile that's always on the lawyers' faces. Because
that's right.
the lawyers that mediate with me often, they know what's coming. They know,
Yeah.
I'm sorry I couldn't get you 600. Oh man, why not? I got you 800. I got you 850. How's that? And then all of a sudden, both sides. So to me, that's a strategy that Glenn, adopt it, do it. It's so much fun. As a mediator,
Yeah.
we want to keep this fun. There's nothing cooler
Right.
than telling both sides that they got above and beyond what they wanted at the
Well,
expense of the
you
other.
got happy people. That because especially in family law, part of it is like they don't make it a business decision. They just want the other side to feel pain, and they feel like they get that with that strategy. So that's perfect.
I'm going to
That
tell
is
you
perfect.
something that's not on this help sheet, but every lawyer and every mediator in the 80 countries with English based legal systems, you should insist the following paragraph be in the mediated settlement agreement. The parties agree that that each attorney fully performed their duty to prepare for and participate in mediation, and the mediator conducted an appropriate mediation, and this party, by signing this agreement, waives any claims as relates to preparation for and participation in this mediation. They waive any issues against their attorney and against the mediator, only as it relates to in the mediation and the preparation specifically up to. So if
Yeah,
later,
I like that.
so if later they decide to sue the lawyer or file a grievance, if it's about the mediation, all you have to do is turn in the mediated settlement agreement, and the grievance board is going to dismiss the grievance because, well, you signed this. And I
Yes.
and I always in mediation I said, okay, you did this whole agreement, but here's a paragraph you haven't read yet, and it's the most important one of all to the mediator and the lawyers. I call it our get out of jail free card within the
That's
language
right.
of our culture in America, right? If you play
Yeah.
the game Monopoly in America or in the Western Hemisphere, get out of jail card. It says,
Yes.
do not sign this agreement unless you agree your lawyer fully prepared for and adequately participated in mediation, allowing you to make your own decisions, and that the mediator gave no legal advice and fully performed their job as mediator in this mediation. And
There you go.
and
Yeah.
and so as a mediator, therefore, you never need malpractice insurance just
That's
by
right.
including this one paragraph. Just if all you do is mediate cases, if you include that paragraph, you don't need malpractice insurance, right? Because if they
Right.
don't agree, there's not a signed agreement and they just go to trial. But as a lawyer, why would you ever not ask your mediator, draft the paragraph in advance and send it to them and say, will you please be sure that this paragraph or something similar is included? The get out of jail paragraph for the mediator and any attorneys in direct preparation for their client and participation in the mediation. So,
That's very good.
there are other topics on our help sheet. Remind the parties that this is the last chance they'll have the opportunity to control the outcome. Make sure that everybody signs it that day. As a mediator, do the e-filing that day. Everybody appreciates it so much. It's such a simple extra touch to save attorney. Sometimes lawyers are mediating from their cars at Tesla charging stations, just like Glenn is mediating right now on the road in his Tesla, getting it charged, right? I'll never forget.
Right.
Side note, Glenn, one of my favorite mediations, the party represented himself pro se, and the whole time he was driving a forklift in the warehouse. But I made him pull over. But I made him pull over, park the forklift when it came time to signing, so he didn't spear a fellow employee to death while he was signing and driving at the same time.
Yeah. Yeah.
Glenn, you're one of the most respected mediators and one of my favorite family law attorneys in the city of Dallas, Texas, in the United States. As always, thank you for joining us. And Glenn, can you tell everybody your web address if they want to look you up?
Yes. My web address is Glenn at BrennerLawPC.com.
And that's
so
Glenn,
it's Glenn Brenner
with two N's. Glenn with two N's.
Yeah. BrennerLawPC.com is the actual web address. That was my email, is the web address. And it's in construction, and I'm working on putting a new site up. But I want to say thank you. And in conclusion, like any other practice of law, when it comes to mediation, either as the attorney or the mediator, preparation, preparation, preparation.
Absolutely.
You come prepared and you're going to be much more successful. You prepare the mediator, you're going to be much more successful. If you are the mediator, the more information you can pull out. Sometimes it's like pulling teeth, and it's not because attorneys are lazy, it's because attorneys are busy and they have a million things to work on and they're not getting you what you need. If you can prepare for that mediation, you're going to have, Tom's got one of the better records in the entire state, I would say, and probably in the country, of getting cases settled, but that's because he does the work in advance. And so there's no substitute for prepping.
And the last thought I'm going to add is, when do you start preparing for mediation? The same time you start preparing for trial, on intake.
That's right.
On intake. When I get a new case as a lawyer, I start my exhibit list and my witness list right away. And I start organizing and labeling my exhibits and organizing my witnesses on my witness list right away. Why? Because if you're always preparing for trial, mediation is just one step backwards.
That's right.
You can include exhibits 1, 7, 26, and 49 because they're already labeled, and you can just attach it to the mediation memorandum. So to me, final trial and mediation preparation begins on intake. And then do a mediation memorandum like the mediation memorandum generator in the mediation suite in Toolkit.law, and then just attach your exhibit list and certain exhibits. And you're going to say, well, here's the picture of X. Here's the smoking gun, as we say in English in the Western Hemisphere. Here's that piece of evidence that, in Latin, that sanctus cacas, that holy shit piece of evidence, to where they go, oh, there's that picture of that person keying that Tesla.
Yeah. That's right.
Right? Okay.
That's right.
Glenn, great to see you.
Thank you.
I hope to see you in mediation soon, my friend.
Yes. Thank you so much. Take care.
What a fun session. And this concludes this recording of this mediation CLE session.